Our guest tonight is a senior advocate of Nigeria. He was called to bar in 1984 and has had an extensive legal practice with deep experience in litigation. In fact, he was a pioneer head of the law school in Enugu. He produced a draft for New Legal Practitioners Act in the country, as well as other legal instruments before the National Assembly. He's a professor of law who is widely published. Tonight, we're joined in our Abuja studio by Professor Ernest Ojukwu, Senior Advocate of Nigeria. Good evening, sir. Thank you for joining us.
Good evening.
Well, let's get into this, because this judgment by the appeal court is quite an interesting one. On the one hand, it voids the judgment of the Federal High Court in Umuahia, but then it seems to uphold some part of that same judgment as well. So can you help us break it down?
Surely, the decision from the media, because I've not read the transcript, the decision from, as we have read from the media, shows that the court decided that the plaintiff lacked local standard to bring the case, and so they struck out the case, set aside the judgment from the Federal High Court. But on the other hand, they also gave an opinion on the constitutionality of that provision of the Electoral Act. That's what, from the media reports we have. So,
I mean, from what we have so far, as it stands, what is the fate of 8412 of the Electoral Act?
Even though the opinion was based on no issue, because they had already struck out or decided that there was no grounds to hear it at all, that opinion, having been made in a judgment, becomes the law. Yes, it is the law, because unless you set this aside, you have to, because they have already given us an idea what the court wants to decide.
But I see you're using the term opinion, not judgment.
Yes, when a court makes a decision that is not based on an issue for them to decide, we refer to it as a mere opinion, as what we call in law obiter. By the way statement. That's the kind of thing they have made there. But so it's not based on, because there was nothing before them anymore to decide. So it is off the record, so to say, in a layman's word. But we call it obiter. So it's a mere opinion, expressing your opinion. If you bring this case before us, we shall say that it's unconstitutional. That opinion, it contradicts their decision on locus.
This is a very interesting one, which is why we have you to really break it down for us. I mean, lawyers will say you can't build something on nothing. So, and you keep saying if this case were to be brought before them, but it wasn't brought before.
Because they said that it wasn't before them anymore.
So can you really build that on nothing, really, in that sense?
You can't. You ought not to. But the state of our law is that even when a court decision or opinion is, so to say, wrong, you still have a duty to obey it until you set it aside. So that opinion of a court of appeal actually destroys their judgment that said that the plaintiff lacked locus.
Okay, just to refresh the memories of our viewers, what exactly this 8412 is about, because that's been one, a lot of people probably know it, but just so we don't take this for granted, let's show you what section 8412 of the Electoral Act, which was signed by the President earlier in the year, says. And this is what that section says. It says, no political appointee at any level shall be a voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. So that is what the law says. But it's still quite curious, really, because some would say, well, the case really has been struck out. So it's as though there was no case in the first place. Is that right?
Yes.
There was no case challenging that in the first place.
Yes.
So some would lean and say, so as it stands, the law is still standing.
Yes, that's how it's supposed to be. In fact, the court was wrong to give that opinion. The court overreached in giving that opinion.
You think so?
It was very wrong of them to give that opinion. Now, we have rules of court that enjoins our judges to decide substantive issues together with preliminary issues that are raised, like challenge of jurisdiction. That if we have such a challenge of jurisdiction, you should decide both together. That's the general rules in our court rules. And based on that principle, if a court decides, because sometimes they may not want to, but if they decide to hear both the substantive matter and the preliminary issue together, they are advised to also say what they are finding on that substantive matter. The reason is to avoid delayed justice. Assuming the case goes on appeal and the appeal court sets aside their decision on the preliminary issue and say they were wrong, the normal thing the Court of Appeal would do is to return the case back to that lower court to now hear the substantive one and make a decision. Now, having had the substantive one, courts are generally advised to give an opinion, decide that, say, yeah, what you found in that trial.
Right. Because
we don't want that case to return to you. It will delay trial. So that at least there will be a basis for the Court of Appeal to
now hear that.
Sure. Now, but the basis for that advice is in cases where there are substantive, real contentious trial where witnesses are called, especially between individuals and human, not government, where witnesses are called to try. You bring 10 witnesses to testify, like a contract tussle.
Right.
Why don't you say, based on these witnesses and what you have had so far, there's no contract for you, or you win. So that we don't return to the court again to begin to
the same process.
But not on constitutional interpretation.
And
courts have no right to say you don't have a locus and then go back to interpret the law for us.
So it's a bit confusing, right?
Yeah.
But something else that we got from that judgment really is that now they're meant to approach the Supreme Court for some sort of interpretation. You have said ideally you should probably go back and start from maybe the scratch or approach things properly. But now it says escalate it to the Supreme Court for proper interpretation.
No, in this type of case, where the contention will just be mere interpretation of law, our appellate courts also have some powers to do that trial and interpret the law.
Which they may have done stylishly with that opinion.
Not when they have already ruled that there's no locus. In fact, our courts have had, for some years now, we have had the habit of jumping into political issues to decide political issues. Well, all the things we learned in constitutional law is that the court should avoid.
But is this a core political issue or more of an electoral? In fact, some would even say it's a governance issue. It's a democratic issue, which is why you have the courts in any case.
They are all not democratic or governance issues, but this is a political matter. There are no single individual is involved, but there are some tussle. There's some tussle between groups of people in the political affair. And if you look at even the substantive decision itself, if the decision of the Court of Appeal was based on Section 42, 1A of the Constitution, they were also wrong. Section 42 talks about those who shouldn't discriminate against, and the Constitution lists those people in all the provisions of Section 42 on grounds of community. You shouldn't be discriminated on grounds of ethnicity, on grounds of sex, religion, or political opinion. There's nothing in that provision that says you shouldn't discriminate against somebody on grounds of political appointment.
This keeps getting interesting, Senior Advocate. But let's talk about the second leg, which you have talked about. And some will wonder, why will the Federal High Court in Umuahia entertain a case for which the person who is instituting that case, the plaintiff, doesn't have locus standi? It would seem as though the appeal court essentially said, you didn't do your job well. You didn't do due diligence for giving that. So it beats the mind. Why was that case entertained in the first place?
Well, judging is not a simple matter. If you sit down as a judge, you will find that the burden, you are actually on trial. The body
even as a judge.
In fact, once you have a case before a judge, it's the judge that is now on trial. It's a big burden, and many times, and with their docket, large number of cases they have to try. Many times, everywhere in the world, judges will depend on the lawyers, on the parties, what they have argued before them, to a great extent. They are not to go on their own research, and so if they have that, if in a particular case they were unable to remember to broaden their thinking in relation to the issues, they may make such mistakes. There were also decisions by other courts on that same subject matter filed in other courts in Nigeria at the same time, and one or two of those courts held that the parties didn't have local standing. There were decisions like that.
It's quite interesting. So essentially the judge will decide based on what the lawyers present,
Generally,
as much as possible.
As much as possible. That's why we need the parties to do the job very well.
So now that happened at the legislature, but then the president also made his pronouncement saying that those vying for elective offices in his cabinet should resign. How constitutional is that? Because it would seem the court is saying that provision in the Electoral Act is unconstitutional, so nothing should naturally bar these people from seeking elective office or participating in party primaries. But the president says, if you want to go that route, you must resign.
Yeah, the president is right now, but what I don't know whether he's right on his reasons. But we don't need a constitutional provision or a legislation to ask political appointees who are assisting an executive president to resign at this time, about a year to the next election, when they are going to go into tussles for the post through their primaries.
But the Constitution provides for some of that. We've seen Section 137,
That's
182. Exactly. And if we could just take a look, just for the benefit of our viewers, Section 137, 1G of the Constitution. Now, this one talks about a person shall not be qualified for election to the office of president if being a person employed in the civil or public service of the Federation or of any state, he has not resigned, withdrawn, or retired from the employment at least 30 days before the date of the election. We're still just less than a year from the date of the election. So really, can't they still stay in office?
No. The political appointees, like the ministers, don't need any law to resign 1 year in advance. Once a decade, they want to run for serious political positions like president, governor, senator. You see, these are the people appointed to carry out, execute the work of the thinking of the president. They're not just political appointees as such. The president didn't appoint them thinking that he was going to promote them on a political level. Right. He appointed them to go and serve me, go and work. And you suddenly come and say you want to go and change job. That means you are going to have conflict of interest. You're going to go pay attention on my job. So it does not require law for the president to fire them.
The Constitution does not expressly say. So if they actually stay in office, is it unconstitutional?
No, they shouldn't stay.
Is it unconstitutional if they stay in office?
It is not, based on this decision today, it will not be unconstitutional for them to stay. Based on this opinion the Court of Appeal have rendered today, it will not be unconstitutional. But I hope that opinion will be set aside soon. But it's important to note that if the president does not fire them, and the president has the right to fire them, he can fire and hire.
Yeah.
Now, for example, the ASO strike we are talking about has been extended by another 3 months by ASO. And there are two very serious ministers that are in charge of helping that decision to be made. One, the Minister of Education, and two, the Minister of Labour.
This is the Minister of State for Education.
Yes, for education, but he is in charge of that portfolio. And then the Minister of Labour, who is in charge of negotiation. Now, and you can see that both of them have not been paying attention to the ASO strike, because they have been bothering themselves with running around their political issues. That's why you must have...
Even though they've held some meetings.
Well, sure, but you know, when you have something personal that conflicts with the public duty, you are going to face up. If you have health challenge, money challenge, post challenge, and you have a duty for the public, you are going to pay more attention to your own private interest. And that's one of the reasons why they must go. And Wajoba, you must applaud him, has shown a pathway, a disciplined example, that I can't concentrate on this my job anymore, because I'm ambitious now to be appointed, to get a political post. So I go. So the others must go. Otherwise, the president's work will come to a standstill. They should go so he can decide who and how he will manage the next 1 year. Because everybody is saying that a lot of problems in the country, security and so on, and these people are in charge. Attorney General is in charge of our entire legal system. He is the chief law officer. How can he be running for governorship of a state and he's still managing, helping us decide whether we're alive or dead?
You know, it's quite interesting when we discuss law, because lawyers will tell you, well, if it's not in the Constitution, you can't push the moral angle on me. I'm not going to sometimes go and argue the morality. It's the Constitution. So definitely there will be other sides to this, but I want to just get your, well, maybe not legal opinion, but as a Nigerian, as someone who is vast in this field, do you think now this is a test to know who is really in for this, who is trying, who has the best interests of the nation. Do you think this is a test to see who resigns and who does not resign?
Surely. You know, we use this word in Nigeria, tumbon. This is not a time for tumbon. Anybody who wants to lead us must show seriousness, and this is a test for that seriousness.
So can we say those who maybe don't resign?
Of course, they are playing with us. Those who don't resign are playing with us.
There's an issue I'd like to get your intervention on. It's a bit knotty as well, and that's the National Assembly's move to amend yet another part of the Electoral Act. That's Section 84.8. And this one is quite different. It talks about statutory delegates. And just for the benefit of our viewers yet again, so we're on the same page, we'd like to show you what Section 84.8 says as we wind down. Now, it says a political party that adopts a system of indirect primaries for the choice of its candidates shall clearly outline in its constitution and rule the procedure for the democratic election of delegates to vote at the convention, congress, or meeting. Now, the thorny part is that election of delegates. And apparently, it looks like they didn't make provision for statutory delegates. It just says you have to elect the delegates. What do you make of this, really?
They've amended it now. And they've now said they will be delegates. That's what I've just declared.
Now, the president has to assent to that.
He has signed it already.
So that's done.
Oh, it's gone. Because all of them suddenly found out, oh, we don't even have a right to vote for ourselves. So they have now woken up to protecting their own turf.
So these are the intrigues.
It's a private interest. They are purely private interest.
Well, I'm glad you've cleared the air on some of these issues, and I'm sure our viewers also appreciate that. But we'd like to thank you so much for your interventions. We'll be speaking with Senior Advocate of Nigeria, Professor Ernest Ojukwu. Thank you again.
Thank you.
Well, let's take a breather now, shall we? But here's what we have for you next. A continuation of our conversations with presidential aspirants. It's his second coming, and we'll be exploring the game plan of this technocrat turned politician. Professor Kingsley Moalu is up next. Stay with us.